Everyone, welcome back from lunch. I hope you've seen some great examples. I know I've learned a lot. I hope you've seen some great examples of the work that we do across the council. We again, we work at many levels. You've seen people who are building tools. You've seen people who are taking advantage of tools to do deliberations in their community. We've seen some questions in the chat like, okay, so you're building these tools. How do these relate to, the dominant platforms where many of the conversations that happen take place? In the next couple of sessions, we're actually going to talk about the platforms where many of the conversations occur and how do we, address the concerns that people have about those platforms in addition to, using new tools and taking advantage of the opportunities that technology affords us. So in this session, we have two amazing speakers with us. We're going to start with Tiffany Gillis Brown. Tiffany is a litigation counsel at Tech Justice Law. Before joining Tech Justice Law, she worked at the U.S. Department of Justice's Civil Rights Division, where she co-led the division's work on AI. And for those of you who don't know Tech Justice Law, you may not know Tech Justice Law as a name, but you should know some of the cases they worked on. They're actually the pioneers of many of the chatbot litigation suits in the country, including the Sewell Setzer case against Character AI. And just really, the impact they've had is just immense. Character AI no longer serves kids who are under 18. I think Tech Justice Law deserves a lot of credit for that. Tiffany's going to talk a little bit about some of the litigation work that she's been doing. Without further ado, Tiffany, please take it away.
Thanks, Ravi. Thank you for the really nice introduction. So as Ravi mentioned, I'm Tiffany Brown. I'm litigation counsel at Tech Justice Law, and we are a nonprofit that is dedicated to advancing accountability, transparency, and just overall justice in the technology sector. And as Ravi mentioned, we've represented a lot of individuals in cases before state and federal court in the US. And, we're mainly challenging harms associated with emerging technologies, including the AI chatbot litigation that's ongoing. But we also work in a few other areas as well. And then something else that we pride ourselves on is really facilitating connections and convenings. And to that effect, we've done policy work and have also authored and facilitated a lot of amicus briefs related to tech accountability issues. So really great to be here to talk not only about our recent litigation, but also about a recent project that we've worked on with in partnership with the Knight Georgetown Institute, as well as USC's Neely Center, where Ravi is. And if you don't mind, I'll probably start there, and then we can go into any questions or anything you all want to know about our chatbot litigation. So we can go to the next slide. So as I mentioned, we worked in partnership with KGI and USC to develop what we call our Designing Technology Remedies framework. And this is really important because we know that there are various tools that we can use to hold big tech accountable for tech harms. And litigation is one avenue. Policy is another avenue. And then what comes out of that litigation, such as remedies, and what comes out of investigations is also extremely powerful. And so in recognizing that, and also in recognizing that tech litigation is getting further through the courts than it has before, because of certain, I think there's a number of factors as to why it's why litigation is moving forward. But as litigation in the tech space moves forward, it's really important for us to learn and apply lessons from other industries and from the ongoing tech litigation that is happening now, to apply those lessons and to create meaningful structural change. And so that's what we sought to do here. And so this framework, we basically analyzed over 100 different settlements and remedies across various sectors like public health. Think about e-cigarette litigation and big tobacco litigation, also tech related litigation in the antitrust and merger space, and some other sectors as well. And we took lessons from those and basically provided a list, or as I like to call it, a menu of litigation remedies that can be adapted for future investigations or lawsuits concerning, namely social media and AI chatbot technology. And it was a long-term effort where, we did that analysis, but we also interviewed key stakeholders like litigators and experts in the space to really try to understand how can we create meaningful change through litigation remedies, and change that actually, pushes or reshapes the way that the tech industry is operating. And so we acknowledge monetary damages alone are not going to really move the needle. It's unlikely to be meaningful when it comes to improving safety for users and for the public. And also, it's not going to do anything really for transparency. And so, again, looking to lessons from the past and from current litigation, we basically have three buckets of remedies that we want folks in this space to consider when they are, attempting to negotiate with platforms or other tech companies. The first is harm prevention, and those are remedies that focus on changing how companies design, develop, and deploy their products. The second bucket is harm mitigation, and that is, really looking at the user, and it gives users tools to act or, for instance, levers to report things or to avoid certain aspects of a product or to meaningfully respond to harmful experiences that they have with a tech. And then that third bucket are governance remedies. And those remedies seek to change really how tech companies are operating, how they're exercising their leadership, and how they are um, enabling independent actors or independent scrutiny to come in and see, exactly what they're doing and how they're enforcing compliance. So I'll very briefly share some of the recommended remedies that we propose that others are thinking about in us and as we go through our litigation, things that we are thinking about as far as injunctive relief is concerned. So we can go to the next slide. So this is probably small. Hopefully you'll get a chance to look at it. This is also a public report. It's about a 50-page report. So if anyone needs access to it, it's up on our website and up on KGI's website, or I'm happy to provide it to you. But in this first bucket of harm prevention, we've included remedies around certain prohibitions. So prohibitions on unsafe design features, or looking at potentially um, default settings on the product for minors and for other potentially vulnerable users. We've also added in meaningful limits on data collection, how data is retained, how it's used, restrictions on targeted advertising to minors, um, and then also thinking about data deletion and disgorgement, which is an important one, because data is usually gold for a lot of these companies. And then, of course, a big topic of today is age assurance safeguards. So we have a whole section on harm prevention going through each of those remedies. Next slide. For harm mitigation, some of the recommended remedies include looking at parental controls, and seeing if those parental controls actually are effective. Do they work? against and measure them against outcome-based metrics, effective account and data deletion when appropriate, data portability, and then also having user systems with concrete response timelines, escalation processes in place, and communications to the user. And then the third bucket on the next slide, some of the recommended remedies that we talk about. And this one is a big one, changing the behavior of the companies. So, for instance, having a senior compliance officer within the company who has teeth, who has real teeth to bring change and real authority to monitor compliance. Also, considering certain uh, company goals and objectives, making sure that those are aligned with safety, having an independent external monitor that's able to audit the companies, um, and then also having the company put in place internal and external measurement processes where they can actually meaningfully get feedback on how their product is affecting their users. And for instance, you think about holdout experiments or user surveys and things like that. And then other sorts of transparency mechanisms, which we saw in the big tobacco cases, having a document repository that holds company documents and company evaluations and all sorts of things that the public can then view and use for research purposes. So those are just, and that's a lot of information. And again, it's a 50-page report, but all of these remedies that we recommend, it's not meant to be a one size fits all approach. It's not meant to be kind of like this all or nothing approach. It's really meant to be a starting place for those that are engaged in litigation or engaged in investigating big tech companies. And it's a menu of options. Certain products or certain technologies are not going to need, or benefit, it's not going to benefit us for them to have certain remedies. And of course, there's also the negotiating process where you're going to have to pull different levers and advocate for different things. So this is really meant to be a starting place for everyone who's using it to think about what sort of remedies make sense for this particular technology, um, and kind of zooming out. Um, what can we do with litigation to actually push policy efforts forward? And so this is where working together and convening and talking about what sorts of remedies are actually super useful really comes into play. And so I'll pause there on the remedies and our remedy framework and pass it back to Ravi if you want me to continue about our litigation or if you want to turn it over to Camille.
Yeah, let me bring Camille into the conversation and just add a little bit more context. One reason why the conversation about remedies, if we want to address these platforms which are so central to civic discourse, um, one reason why the conversation about remedies is occurring is because there have been several significant court cases. So there are the cases that tech justice law has been involved in with AI. There are a couple social media cases. So in New Mexico, there was a court case where New Mexico won a settlement. And so now they're talking about injunctive relief, these remedies. What are the remedies that are actually going to occur alongside monetary damages that could be informed by some of the things that Tiffany has talked about? There's also the case, the Bellwether case of a young person who was harmed by Instagram and YouTube. Again, they won the case, and now they are actually talking about injunctive relief. So these are active conversations where we want to understand what can be done to not just compensate the victims in these cases, but also change these platforms so that future citizens are not also harmed. I'd love to bring in Camille. So Camille Carlton is the policy director at Center for Humane Technology. Um, Center of Humane Technology has been central to raising awareness of these issues. You might have seen the documentary "The Social Dilemma" or the online video "The AI Dilemma." She's been central in policy conversations, so working on age-appropriate design code legislation, for example, and she's been an advisor on AI litigation as well, including the work that Tech Justice Law has been involved in. So, Camille, I'd just love to ask you a question. We've seen these litigation wins recently, some of them that I've described. Um, how exactly does litigation change the incentives in the ecosystem?
Yeah, thank you, Ravi. Really excited to be here and talk about this. Can you all hear me? Yes, okay, great. Um, I think that if we just zoom out in general, litigation forces companies to kind of internalize the harms that they have externalized onto users, families, like the public in general. And it does this in two ways, right? We talked about damages, which is really actually putting a financial cost to the harms of their products. And then there's also injunctive relief, which is really powerful. And I think that when we talk about injunctive relief and when we talk about a lot of these cases that we've seen that have taken, a products design approach to litigation, it's really powerful because it's looking at shifting the way products are built from the very beginning, looking at things like, we saw in the MDLs, and the bellwether case, like infinite scroll, algorithmic recommendations, notification notifications and feedbacks like that. And this targets the actual business model of these companies, right? And so one of the things that we face a lot with litigation is that the amount that we see in damages can feel so small compared to the actual size and revenue of these companies. And so it can feel really difficult when you're only looking at damages to say, okay, this is making a dent in how these companies operate. So that's where injunctive relief comes in as a super powerful lever because it's not just about, okay, a company writing a check and in some cases, honestly, having insurance to cover that check, but it's actually saying, here's how you are required to build your product moving forward. And that can have immediate impacts on their bottom line. And I think, one of the other things that we've seen, which is kind of a side effect of all of this is the role of internal documents that surface from discovery, right? So we go through the process of litigation and we've seen how discovery documents that have been surfaced can shape the public opinion, they can shape legislation, they can shape regulatory actions. I think one of the biggest things that has driven change historically has been the disconnect in what companies say that they're doing and what they're actually doing. We saw this being a big reason that kind of big tobacco, kind of the trajectory of big tobacco changed, right? The public suddenly became aware that big tobacco knew that there were harms happening and they did not share this with the public. And so that kind of disconnect changed the way the public understood big tobacco. We've seen that same process happening with social media companies. I think we're starting to see that with AI. So this kind of public consciousness helps also shift the zeitgeist that kind of creates the ecosystem for the types of policy changes and injunctive relief that we want to see.
Great. So, I mean, you mentioned discovery, some of the documents that we've seen from these cases. Just curious, what do you feel like we've learned from these social media cases broadly?
Yeah, gosh, I think that we've learned a few things. I think, in terms of like the internal dynamics, I think that we have seen over and over again that there are teams within these companies that are doing research, that are trying to move the needle, that are trying to improve products. They're pushing it forward, and they always kind of hit a ceiling in terms of what they're able to do and what they're able to change because corporate incentives are always kind of the final deciding factor. And so that kind of leads us to the conclusion that, these companies shouldn't be grading their own homework because as much as, many of these teams try and they make, huge progress within, there's always going to be something that that kind of keeps them from being able to make the changes to the degree that we want. We see the role of public pressure, right? I think the character AI case is a great example where the role of public pressure forced product changes even before having to go into damages conjunctive relief or legislation. Um, I also think that, one of the things that we're learning broadly is how litigation is becoming a really powerful lever in place of active legislation, especially at the federal level. And I think a lot of, folks within the space are starting to see litigation as kind of a de facto mechanism for legislation and policy, and using this as a way to actually change the trajectory of the industry. Um, Given the absence of federal legislation.
Tiffany, did you want to comment?
Yeah, and I agree with everything that Camille said. And also, I just wanted to note that hopefully, particularly with the New Mexico case, hopefully that serves as a blueprint for how remedies, and just gave a whole presentation on all of our remedy recommendations, but how remedies can be used to hopefully encourage structural change. And it also brought to light, I think, that a lot of our consumer protection laws in the country are a little outdated. I think the Attorney General mentioned that the penalty per violation is so low because the law hasn't been changed since like the 70s or something like that. And so it's kind of also has served as a wake-up call for our laws to kind of catch up to um, today, to catch up to 2026. And so there's movement now to actually change, to adjust that per violation monetary damage cost, to adjust it for inflation so that it actually is more of a, like it hits the company a bit harder. But yeah, I think I agree with everything. And that there are so many more cases coming, in the social media cases, as well as in the chatbot litigation cases. And again, hopefully it serves as a blueprint for what we can do through the courts.
Yeah, so I mean, yeah, I'd love to talk more about like what you're seeing as upcoming cases. So, what's on the horizon? I know there's a federal case in social media. I know there's a lot of chatbot litigation that Tiffany, your organization, is involved with, and Camille, you're advising on as well. What cases are coming, and especially, I'd love, we have a global audience here. Would love to understand if you see like international, what is the opportunity globally, not just in the U.S. Camille, do you want to start?
Well, maybe I can let Tiffany talk about upcoming cases, and then I'm happy to talk about maybe more global. Does that work?
Sounds good. Tiffany, you want to go first?
Yeah, so Ravi mentioned the character AI case earlier, but um, after that one, back in October, November of last year, we filed several suits against OpenAI for, defective product. They're specifically ChatGPT, and more specifically, the ChatGPT 4.0 model. And since then, there's been several other cases filed against OpenAI, and those cases have been consolidated so far into a basically almost like a judicial panel, a judicial group where those cases will be um, kind of seen together as a whole. And I think that, from our perspective, the clients that we are working with, um, it's interesting to see that there are harms impacting lots of different people. And so with the social media addiction cases and the social media, deceptive misrepresentation consumer protection case in New Mexico, it was really focused on minors. But our clients are pretty diverse and they're not just in the US. So they are global. And so it's interesting to see that these sorts of harms are impacting different people of different races, different backgrounds, and different ages. And so that's coming up. And it's pending, so I'll have more to share. We'll have more to share, I guess, in a few months, but that's where we are on the open AI litigation.
Cool.
Um,
Camille, global.
yeah, I can add just really quickly. So I think that, global is difficult because everyone, countries have completely different systems, but one that's worth noting is the as of December this year, I believe, the EU's revised product liability directive will essentially include software and AI systems as products that can be subject to liability. So we've been in conversation with a few different groups who have been preparing for this and who are, planning to use this change to essentially launch new lawsuits. I think it's worth noting that the kind of EU doesn't have the same litigation driven, I don't know, essence that the US does. But there is kind of convergence on this idea of product design. And I think we're seeing the EU use this as a mechanism because of the success in the US and because so many of these companies are based here. So it's kind of figuring out how to adjust tactics based off of what might work.
Great. So let me just go to Nick and see if there's a happens to be a question in the room. And if
Any
not,
questions
we
from folks in the room? Go ahead and raise your hand if you have one. I don't think I see any, Ravi. Do you
okay.
see any questions on Zoom?
I do have one on Zoom. So I'm going to ask you guys, here's a question from Josh Ho on Zoom. So here's a quote. What we are seeing currently is a rush to AI dominance, investment in rushing data centers. Companies are inserting AI into everything. How does democracy, slow and deliberative, best check the speed of this rush? And I guess I'd be curious whether you think litigation, legislation, what do you see as the most promising, all of the above, what do you see as the most promising path forward?
Well, I'll start with I know here in the US, Camille mentioned, and we're all feeling the slow pace of movement at the federal level to regulate AI in various ways, environmental justice concerns, workers' rights. I mean, just several the product liability cases that I've been talking about, where the products are, you know, giving horrible advice or pushing people to do things that are harmful. And all of that needs to be, um, s- scaled back and really thoughtfully deployed. But I think to our earlier point about the prior legislation, I'm sorry, the prior litigation with the social media addiction verdict, where we saw all of these internal documents. Um, I think transparency is going to be a critical lever, actually showing the public how these companies are operating and what their motivations are, and bringing that news to a national scale so that people actually vote based on, whether people are actually serving them or harming them. And I think that is one of the biggest things that has come out of the tech litigation recently is that people are now becoming aware of the issue that big tech is. And so I think hopefully that will cause folks to vote a certain way, which would then apply pressure to the people that are in power to actually create change.
Great. Camille, last word.
Yeah, I mean, I think it's such a fair question, and I don't think that we can adequately hold this question without also talking about the role of tech lobbying in our democracy, right? I mean, AI super PACs right now have funneled over, I think it's 190 million into the 2026 midterms. So we're kind of faced with this huge monolith of these companies' influence over the decisions that are being made. That said, and kind of underscoring Tiffany's point, I think that the data center debate is a great example of people taking the debates locally and actually advocating for what they want and what they need. And I think it's powerful because not only do we see how it's working, I think people need to feel like they can have a win and like they have agency here, right? And so if we can elevate this and say, look, actually, like we do have a choice and we do have the ability to change in some ways, and it can start local and it can start by showing up. I think that that's going to give people the type of kind of motivation that they need, because I think the biggest fear is people being apathetic about it and saying that there's nothing that can be done. And it's really easy to feel that way because of the system at play and because of the lobbying. And at the same time, we are seeing people starting to come together and say enough is enough.
Well, on behalf of those people, just want to thank you both for the work that you do, both in litigation and advocacy and legislation. And again, we put the report that Tiffany mentioned that shows, the concrete remedies that may result from some of these cases, and we'll certainly be continuing to follow your work. So thank you guys so much for your time. Really appreciate you being here.
Thank you for
Thank
having me.
you.